Hello, I'm Alexander Jeffrey, a summer associate with the Clark-Esposito law firm. Today, we will be discussing export controls, specifically deemed exports. In this presentation, we will discuss defining deemed exports, defining regulated technology and software, and finally, deemed export exceptions. First, we must define deemed exports. Releasing or otherwise transferring regulated technology or software code, but not object code, to a foreign person in the United States is considered a deemed export. The release of this technology or software is considered an export to the foreigner's country of citizenship and is thus regulated by the Bureau of Industry and Security, BIS. These transactions typically happen on universities with high technology research and developmental institutions, with biochemical firms, and organizations in the medical and computer sectors. Foreign individuals with permanent resident status, U.S. citizenship, or a grant of protected individual status are exempt from the deemed export rule. To understand deemed exports, we must have a knowledge of source code and object code and the difference between the two. Computer code generally is the compilation of written instructions and reasoning for running software on physical technology. Computer code is distinctly different from data, which is the information saved by the computer. So source code is the code written by a programmer in C++, Python, Java, or any other coding language. This code is written in a form similar to English language, and this is what is regulated. Object code, on the other hand, is the code that is translated from the source code to a form that the computer can read, understand, and execute as a command. Now we will speak more generally about regulated technology and software. BIS does not regulate technology or software that arises from fundamental research that is intended to be published. Fundamental research is defined as research in science, engineering, or mathematics that is broadly shared with the respective community. Researchers that decide to restrict the access to technology or software that would regularly be published must file their research with BIS. The decision to restrict access or privatize the technology or software prompts BIS regulation. Now we will talk about the process of release. Release is the term used for the conveyance of the regulated technology or software to another individual in circumstances that would prompt regulation by BIS. BIS requires that the U.S. party obtains the proper licenses or filings for the technology or software before it is released to the foreign entity. The codified definition for release is given. Except as set forth in Section 734.18, technology and software are released through 1. Visual or other inspection by a foreign person of items that reveals technology or source code subject to the EAR to a foreign person, or oral or written exchanges with a foreign person of technology or source code in the United States or abroad. Secondly, any act causing the release of technology or software through the use of access information or otherwise to yourself or another person requires an authorization to the same extent an authorization would be required to export or re-export such technology or software to that person. Next, we will discuss the activities that are not exports, re-exports, or transfers in terms of deemed exports. 1. Launching a spacecraft, launch vehicle, payload, or other item into space. 2. Transmitting or otherwise transferring technology or software to a person in the United States who is not a foreign person from another person in the United States. 3. Transmitting or otherwise making a transfer within the same foreign country of technology or software between or among only persons who are not foreign persons, so long as the transmission or transfer does not result in a release to a foreign person or to a person prohibited from receiving the technology or software. As a note, any export, even a deemed export, cannot interact with any blocked person or sanctioned entity. Now, on to the last two activities. 4. Shipping, moving, or transferring items between or among the United States, the District of Columbia, the Commonwealth of Puerto Rico, or the Commonwealth of Northern Mariana Islands, or any territory, dependency, or possession of the United States as listed in Schedule C, classification codes and descriptions for the U.S. statistics, as issued by the U.S. Census Bureau. Lastly, number 5. Sending, taking, or storing technology or software that is unclassified, secured using end-to-end encryption, secured using cryptographic modules, hardware or software, compliant with federal regulations, and not intentionally stored in a country listed in Country Group D5 or in the Russian Federation. Now we move on to the licensing process for deemed exports. To obtain a license for a deemed export, an exporter will follow the same procedure as a regular export. Before the release of the technology or software, the exporter must file a BIS 748P form through BIS Application Processing System (SNAP-R). Along with the standard forms, the exporter must also submit a letter of explanation and resume for the foreign party. The standard information needed for requesting a license includes information about all parties involved, the amount to be paid in the transaction, if applicable, the destined country, the Electronic Control Classification Number, which is the ECCN, that regulates the transaction, and the identification number of any prior or similar license requests for the same individuals. Now, a special requirement for licenses for deemed exports is that the foreign party submit a resume. BIS examines the foreign party's resume to establish a greater scope of how the technology or software may be used once released. The resume must include the individual's personal background, including their place of birth and residency, their full educational and vocational background, and any military service, as well as their full employment history. Along with the resume, BIS offers an optional section for applicants to present any special information. This information would include statements about the unique skills of the foreign party and why they are needed for this particular transaction. The last special requirement for a deemed export license is a letter of explanation. The letter of explanation will be the most technical part of the application in describing exactly how the technology or software will be used and all projected benefits from this use. With deemed exports, the release of technology and software is often done with the purpose of the foreign national working a specific job or project with the applicant. This letter prompts the applicant to describe exactly how this dynamic works and how the work will be facilitated. In a situation where the foreign national works for the applicant, the letter of explanation is used to disclose the availability of foreign or domestic parties with comparable skills, where the foreign national will physically work, specifically what work the foreign national will be doing for the applicant in the grand scope of the project or business, and what will be produced using the software or technology. In summary, we discussed defining deemed exports, defining regulated technology and software, and lastly, deemed export exceptions. Here at the Clark-Esposito law firm, our goal is to help streamline the global business operations of importers, exporters, and the companies that support them. So if you have any questions, don't hesitate to reach out to us. Thank you for viewing.